Okay, just a quick thought on what we call the Four Corners Rule for interpreting legal documents. Welcome to Whatsoever More or Less. My name is Jason. Now, my channel has a name for a reason, is that I couldn't help but believe when Doctrine and Covenants says that regarding the laws of man, whatsoever is more or less than the Constitution permits or calls for, comes of evil, right? And now there's been all these traditional ideas that we've heard from the different founding fathers regarding how the Constitution is supposed to be interpreted. So I finally settled on an idea that if the Constitution itself doesn't agree with that particular founding father, I don't care if it's James Madison. Um, if I cannot find where the text actually 100% supports what they're saying, then it can't be true because you have to consider at the Philadelphia Convention, there were like what 90 people invited, 80 something people, mostly 50 something people attended. I think right around 40 or so were left to the very end, and then the Constitution was done. Now, do we have a commentary from every last one of those people that attended the convention telling us what they meant when they wrote it? And why would that matter anyhow? Um, unless they're 100% all on the exact same page in their understanding of the whole thing, it doesn't matter. Okay, the legal document has defines how to ratify it, and so getting the opinion of one of the framers is not a part of defining the Constitution. It just is. It's useful for perspective. And so the Four Corners Rule, this is what it is. It's not that you isolate a single clause or a single article and reread that over and over again. What does this say? But you learn every last clause in every last article, every last little bit within there. You cross-reference it. Okay, how does this clause relate to that clause? What's the connection? What do these all imply by the time you get them all together, right? That's the Four Corners Rule. It's not an isolation, and let me see how I can stretch this one clause. And it's not a, well, let me go outside of the whole thing and see what this guy who was involved in the process for all of 2 days said about it, right? You got to remember, too, there's all these people who participated at the conventions, that they had their understanding upon which they were willing to let it be ratified. And the Bill of Rights, that changed a lot of what's in there. So, anyhow, I am going to point to somebody who I generally disagree. I shouldn't say disagree. I actually agree with overwhelming majority of what he says. He just had a higher tendency to stretch the Constitution than the others, and that's Alexander Hamilton. Um, he was right, if you ask me, when he told Thomas Jefferson in response to Thomas Jefferson's response to the Barbary pirates. He said, "That's ridiculous. Basically, that you're turning around and asking for a declaration of war from Congress, because the fact of war already exists. The moment the Barbary pirates started it with us, we are not waiting for a declaration of war. You go in and you get those guys. That's your duty. That's what the Constitution lays. Go and read it for yourself. It's something number one. It's thoughts on the Constitution. That's not it, though. Look up the title of it. It's basically just do a Google search for what Alexander Hamilton said about declarations of war after the Barbary Pirates incident. He said that the need for a declaration of war became nugatory because of the behavior of the Barbary Pirates. Um, I 100% agree. That is literally, when you study the Constitution, that's what it bears out. It does not bear out the view that Madison or Jefferson said when they said that the power to go to war, it has to be approved, period, by Congress, and that the president only has defensive authority just long enough to stop the immediate ongoing attack, then go ask Congress for their approval. Alexander Hamilton pointed out, he's like, so basically, we're going to hold ourselves to a higher standard than the ones attacking us and give them time to regroup while we go and ask Congress for permission. That's totally not the responsibility of a commander in chief when it comes to common defense of the nation. And so, anyhow, I stand by what I said, and I stand by the Four Corners Rule, and I stand by what the Doctrine and Covenants says. Whatsoever more or less comes of evil. Look, in the end, we have been told in the talk Jesus Christ, Gifts and Expectations by Ezra Taft Benson that the Constitution, it cannot be true that the Constitution is what the Supreme Court says it is, that we would be better off to look at the tradition of the founders and look to the tradition of the prophets. And even then, you're not going to find it 100% consistent. You're going to find differences, as I just pointed out, between Hamilton and Madison, two participants in the Constitutional Convention, or Thomas Jefferson, who didn't participate but was a majorly important founder. I think if you look at the Declaration of Independence for some perspective, that's useful. They complained where the British weren't willing to defend. They expected defense to happen. And other than that, their big complaint was on exercises of powers. And I think the Constitution bears that out, that when you look at it, it's set up in such a way that internal powers are only designed to be exercised through Congress passing bills, which then has to go through a bicameral Congress, then the president's signature, if not a veto override, right? And it has to actually be part of the enumerated powers. There's so many checks and balances against that, but that's exercising of internal controls, right? But when it comes to common defense, you don't see so many checks and balances as you do. The president is out now, the commander-in-chief of the Army and Navy. He has the Take Care Clause, and the Constitution itself declares itself a law, which the Take Care Clause is that he shall take care that the laws of the land are faithfully executed. So in other words, imagine somebody saying, okay, you're not getting it done, I'll take care of it. That's what I see, and that's just what the text bears out to me when you thoroughly cross-referenced within the four corners of the Constitution. So another thing too, the Constitution doesn't grant one branch the power to take powers away from another branch, or to give powers to another branch, to redelegate them. So Article 1, Section 7, Clause 3 specifically prevents that kind of thing, but it's really the only one is Article 3, Section 2, Clause 2 allows for the Congress to remove some of the Supreme Court's jurisdiction, which nobody talks about that because that's totally not the way we live the Constitution right now. But for Congress to pretend like they can augment the president's war powers or reduce the president's war powers by way of a simple Article 1, Section 7, Clause 2 act, no, there's nothing. Powers are granted through the constitutional process. They're taken away through the constitutional process, except for where the Constitution says those powers can be taken away through a simple legislative act, which the only time I find that is Article 3, Section 2, Clause 2, the exceptions clause. So if the power doesn't exist, the power to grant new powers or to diminish powers that exist does not exist at any point in the federal government. That means the only way to change it is to change it through the amendment process, which at that point you have to involve the state legislatures along with the federal legislature. And that's just a simple, solid understanding of being able to talk about all parts of the Constitution at all times. So say, for example, Article 4, Section 2, Clause 1, the Privileges and Immunities Clause. Some people might say, well, the states have to apply, for stopping of domestic violence. If that domestic violence is happening against somebody from outside the state, period, that falls under the Take Care Clause. The Constitution itself declares itself a law. And so the president has to take care of it, even if the 11th Amendment stripped the Supreme Court of jurisdiction on those things, right? Or say, for example, too, there's domestic violence happening and the governor or the legislature thereof has not had time yet to apply for the president to come. Perhaps they themselves are under siege. Does the president sit there waiting for them to apply? Come on, that's the stupidest thing I've ever heard in my life. No, he has the Take Care Clause, and the Take Care Clause ensures domestic tranquility. So where he sees that there is domestic violence, perhaps even happening against the governor and the capital, what have you, period, it's just his job. Anything else would be abdication of duty. And you can get that so easily from the four corners. Really study Article 2. Make sure you know what you're talking about. If you're going to start saying, if all you've studied is Article 1, Section 8, you know nothing about Article 2. You have to study Article 2 again and again. Think hard about Article 2, Section 3 in particular. What is that really saying? Okay, these accusations of, it's suspicious that Trump met with Netanyahu or something like that. I'm sorry, dudes. I'm sorry. I don't want to be mean, but look, dude, that's silly. It's literally part of his Article 2, Section 3 responsibilities. Um, so learn to read the whole document. Learn to read everything in between the four corners. Don't specialize on this part or that part. Learn to read the Bill of Rights. We should have been treating Amendments 2 through 8 like they were always part of the privileges and immunities at all times. We shouldn't have had to wait for the 14th Amendment, which, by the way, the ratification of the 14th Amendment, let's face it, later on there was a case called, oh shoot, uh, Powell v. McCormick, where basically the Supreme Court said, yeah, there's nothing that allows Congress to invent new qualifications before admitting a new member's re-elected or elected to Congress. But that's exactly what they did in order to get the Reconstruction Amendments ratified. They forced the newly elected legislators to have their state participate in ratifying those amendments before they would let them be seated. So those are illegal amendments. That's all there is to it. And at some point, a remedy is due. But we don't need those amendments because amendments 2 through 8 were always meant to apply to all people anyhow. According to the plain text, I don't care what John Marshall said or this guy said or that guy said. Read within the four corners. What's the plain text say? Period. No level of government shall infringe upon the right to keep and bear arms. Anyhow, sorry about that. Wind is blowing here. All right, I'm going to head up to my house now. Have a good day.